I'm Peter Kaczynski, and to my right is Greg Peterson. To my left is Andy Spano, and on video is Commissioner Kellner. So we will begin the meeting with a motion of the minutes of March 19th. Do I hear a motion to adopt?
So moved.
Second?
Second.
All in favor?
Aye.
Aye.
Opposed? Aye. So those are adopted. And we will move on now to unit updates. And our first unit is the executive, Bob Brehm and Todd Valentine.
The work of the agency to prepare for today's meeting took a good part of the work that we have been doing as a unit and an agency. I think most importantly, we'll start with budget. Budget was adopted since our last get-together. There were no new funds appropriated to the agency, and the co-executive directors have had 3 in-person meetings with representatives of the chamber and the division of the budget, and 2 conference calls with the Office of General Services in order to review the fiscal situation to make sure that we are aligning our plans with the monies that are available. I think the easiest to report to you is there's a little bit more work to do, but we anticipate at your next meeting to be prepared with a recommendation that you consider expanding the use of the state cybersecurity funds for the day-to-day operational expenses of the agency should that need arise. I anticipate that need will arise somewhere in the September-October period of time of the year. So we prefer that for planning purposes to recommend at perhaps our June meeting, if that's the next meeting, to have that ability. So for planning purposes, we don't wait till the fall to do that. So from a budget point of view. Also from a budget point of view, there were a number of brand new pieces of legislation that were, that have impacted elections included in the budget. The state board participated at the request of NYSEC, the New York State Association of Counties, to have a webinar with county chief officers and the leadership at NYSEC to review the chapter law changes. It was also the information that we shared in the county telephone call last Thursday with boards of elections as far as the many chapter laws. An example of making uniform the primary hours of all counties beginning next year from 6 a.m. to 9 p.m. instead of those counties outside of the 9 that allowed all-day voting, but everybody else had a opened at noon, so it'd be uniform throughout the state. The 3 hours of voting time off for voting went into effect. The state board updated the information that's posted on our website, the notice that employers need to make available to their staff based on the new wording. We did that update to that document when we did post it to the website and give it to all the county boards. We are also working on an FAQ because since we posted it, there are a number. And so we were trying to gather those questions and put out an FAQ as a way of trying to resolve them instead of answering the same question repeatedly. Online voter registration is another item that was in there, and there are several others. So we're beginning planning purposes as far as what further impact the new laws will have on the work that we have to do, the deadlines to implement them, and again, there's no new money in the budget to pay for any of these items. So to the extent Bill Cross and his team have at least looked at them and given a preliminary evaluation on what work we might need to do and how much time and money it might take, is still in the process for those new bills. I think one item that came out of our discussion last Wednesday with the Division of Budget, the wording that we had heard discussed during negotiation on the budget, and we asked in the room last Wednesday, was how did the Division of Budget think we were going to fund implementing online registration, since they said we needed no more appropriation authority to get that task done. And their answer to us was to put together a plan, and they envision the funding would be sub-allocated to us through the state infrastructure, which is a large capital fund. It still has a 2-year implementation deadline, which is in itself going to be a task. So we will need to follow up, if that's the path we're on, to come up with the estimate as to how much money we would need sub-allocated in order to kick that project off as early as we can, to have any chance of getting it done in 2 years. But at least, you know, they've confirmed to the state board that which we had heard through rumors behind the scenes anyway, which was the approach that they were looking at. So that's the path we will follow, at least, to identify how much we think the project will cost, and then start working to sub-allocate the funds to make that possible. The only other item, I think from a budget point of view, which is a big one, is a full accounting of all of the remaining Help America Vote Act funds. The state board received a communication from the Federal Election Assistance Commission identifying that all of that myriad of grants that we got back from the initial one in 2000, when they sent every state $5 million out of the Help America Vote Act, and then they subsequently made several appropriations over time. They are reevaluating all of those grants to try and, because they all have different start and end authorities, to try and summarize and bring them to a conclusion. There's still forever money, and from our review at the staff level at the state board, the Division of Budget and Office of General Service, who host us for keeping track of all of these grant funds, to be sure, there's approximately $12 million, little less than $12 million left in a appropriation of those Help America Vote Act dollars to county boards of election. The majority of that money was old machine money that some counties had spent it all. Other counties had some left. At the end of that buying of machines, the residual amounts that were dedicated to each county were in a program that has an acronym that I forget the words of the acronym, other than it's called the Shoebox Grant Program. There's another approximately $2 million of federal money that was appropriated by the legislature for use by the counties for poll site training and access related efforts. So we need to combine those two. It's just shy of 12 million. Available to the state, and the total appropriation that's still available is just shy of 17 million. The delta is what the state has available to it. Some of that money is already dedicated to the NICE voter update, which is a deliverable-based program that the vendor is still working to deliver all of its services. So some of it is encumbered against until the vendor finishes, which we anticipate soon, and then very few other dollars are in that category. But there are restrictions on what we can use that, the state of New York can use that money for. It has to further the administration of a federal election. So one example of what we couldn't use it for is to update the FIDES system, because the campaign finance system for the state of New York in no way furthers the administration of a federal election, because the federal government totally regulates campaign finance at the federal level. So we will examine those funds and recommend to you if there are any of the cybersecurity improvements or the technology improvements that would benefit from the use of those funds. And hopefully we will have finished that in very short order, long before the next, we hope before the next meeting, so that we can at least give you, here's what we have, here's the list of to-dos, here's the list of to-dos that would qualify for the use of this funds, and if it's your consensus that we follow that path, then we would ask you to give us that approval at the next meeting. But we have examined every appropriation, we have examined every reappropriation, we have examined the cash that's in the bank account behind every reappropriation, and we still are at about $2.8 million deficiency in the funds that we have available for personnel and contracts. That may adjust a little bit if we can identify some of the work that we're doing that might be able to use the federal funds. That being said, we have encumbered under the grant program for cybersecurity and infrastructure improvement certain projects that will protect the county boards of election systems, and certain projects will protect the state board of election programs. We are advancing on those projects because they are paid for 100% with the federal grant money, or they're paid for out of the 5% state match, which is about $1 million that we have dedicated out of the state cyber money, because that's the only money we have to pay the 5% match. Those are continuing because they are dedicated funds to that project that you've already approved that we participate in. And I think Mr. Cross can give some information during his report on that. Other than that, we worked to get some feedback on the regulations that my RITF staff in the units of the agency helped to draft, to get them out to counties, to get comments back from county boards of elections. We worked to incorporate as best we thought we could the comments that we received to give you an amended version today. So I thought it was helpful to get those out. They were also posted to the state board website when we were able to share them with the counties, so that they had been out in the community for more than a week. And certainly these will be recommendations that there be emergency regulations, because there's certain deadlines that are in the regulations that are coming up. And then they will take their normal path after that, and we'll have the normal posting and comment and come back to you for a final version. I would anticipate that they might change, but at least I think they're in a spot now for you to put in place, and knowing that we're going to continue to examine them. I think some of our next steps that we discussed at the Taunton High is to work with county boards of election to put together a kitchen cabinet advisory group to try and do that. And once the regs are, a version of the regs are in place, to start working on the procedures behind those regulations, to put meat on the bones of the procedures. Many of the existing opening and closing procedures that we've used for years since we've gone to the new systems in 2010 will probably need a little tweaking in order to accommodate early voting. So we're looking to get together a small group of both ES&S-based counties and Dominion-based counties to how best to document and get that out as early as we can. So we'll be looking to do that. And certainly we know the next month at a minimum we'll be focusing on the e-poll books. And that is an important project to try and move forward. We had numerous meetings with the Office of General Service on a procurement process for electronic poll books. We, based on the advice of Office of General Service, an initial request for information was put out to the counties and to the vendor community and the public with proposed functional requirements and security requirements. Feedback was obtained. OGS had indicated initially a couple of avenues that might be available to get the contracts in place quickly. And they have settled on, after examining more information plus the comments, to do an RFP process. So while the state board is moving forward on an approval process for this equipment, OGS is working to put in place a contract that, based on whatever we approve, would allow counties to purchase them. Their estimate is to have those contracts in parallel with the work we're doing, to have the contracts in place in July. We have strongly encouraged as early as possible to have those contracts in place, and anything we can do to help expedite that, we have offered to do.
Counties can purchase themselves without going through the state.
As long as they meet whatever their local procurement, so some
So
are.
they don't have to wait for us to have a contract?
Correct.
Yeah.
If they meet that requirement, their procurement requirement. So some are looking at similar, you know, can you piggyback off an existing contract? Can you do your own procurement? Some counties might be small enough that it's a de minimis, you know, under the threshold of what they would have to go out for public bidding. The only standard that we have is it has to be on the state list, and we're working to make that happen. And I think that covers the breadth of what we're doing. But
No, that's the basic gist of all the major projects. I mean, the biggest challenge we're facing is that, you know, there was no money added for any of the new projects. And we're, as you've heard from Bob, we're gonna have to, at some point, probably adjust our state cyber plan to reduce the amount of money that would have gone to the counties to cover our day-to-day expenses. Because we can't find it in the money, and trust me, we're looking diligently for every coin in the couch cushion. And the fund's there, so, you know, the agency will be fine, but that will have an impact on the counties going forward.
Okay, any questions? No? Okay, thank you, and then we'll move on to Council's office, Kim Galvin and Brian Coyle.
Thank you very much, Commissioner. It has been a busy time in the Council's office and in the compliance unit. Obviously, the unit was involved in the preparation of the draft regulations that are before the Commissioners today. It was also a period of ballot access filings, which engendered a number of questions from counties in terms of changes, given the June primary timeframe. There were, of course, specifications received by the board that were processed by the agency, and the Council's office participated in that with other units. In the area of case updates, one of the things I'd mentioned, we're not actually a party to this case, but the Court of Appeals is taking up oral argument on the ballot images being available by FOIL case, Cosmeter case. That's on May 1. In Common Cause, we maintain a posture of depositions and discovery, which will be ongoing for the next several weeks. In the Sugarman v. NISPO case, the matter has been submitted. Both sides have requested oral argument on the matter, but that has not been scheduled as of yet. Also, in the period since the last meeting, there have been roughly 8 ballot access related cases, none of which actually have anything to do with petitions that are filed here, but involve the state board as a necessary party or putatively as a necessary party in those proceedings. We also have a HAVA administrative complaint hearing, which will be occurring tomorrow, and we posted guidance with respect to loans by PACs or lobbyists to candidates or candidate committees to effectuate a change that was in the adopted budget. The compliance unit training season has begun and has involved the training unit going to Dutchess, Westchester, and Orange counties. And they have 10 more trainings scheduled upcoming in May, and 4 additional trainings in the month of June. Also, the compliance unit has been working with filers to update emails in anticipation of the new web-based software system, which requires, in order to use that system, that we have emails for the treasurers for authentication purposes. And the IT unit has begun training the compliance staff to beta and beta testing the software, and so that is underway, as well as the 2018 statewide and legislative audits. In the area of campaign finance disclosure reports filings, the update is that with respect to paid internet and digital advertisements, our running total is 134 filed from 92 different independent expenditure committees, and of that number, they have been 110 of them have been posted to the State Board website. The status of the 2019 January periodic failure to file is that there are 2,652 committees, and 99% of those, as would be expected, remain outstanding. With respect to the 2018 July periodic filing, 2,500 were referred. Of those, 2,171, or 87%, remain outstanding. With respect to the 2018 January periodic, 2,530 were referred, and 72% of those 1,000 outstanding. In the area of deficiencies, 113 remain referred. Of that number, 1,317 are still deficient. 384 have come into compliance.
Brian, what's the time frame of those deficiencies?
That deficiency number is from inception to now, and there in that number, a total of 2,650 were actually referred at some point or another, but 837 of them were reclassified as training as the criteria shifted over time. So the fair beginning number is 1,813, and again, of that number, 384 have become compliant. In terms of the aggregate work of the compliance unit, 121,767 filings have been received, and they are keeping up with those very well. 111,795 have been completed in terms of their review. In terms of hearing officer reports, there were 6 requests for a hearing officer last year, 6 the year before, and as of right now in 2019, the number is 0.
Okay.
I just have one thing to add. If you remember, the LLC law that went into effect required a breakout of ownership for attribution of the funds they gave. Some LLCs are starting to file their ownership interests, so even though it's not due till December 31st, so we're working through some of the issues with creating a standardized form for them to file, should any of them be listening to us now, and we should have that forthcoming.
And that's something that the filers have to use in order to identify who their LLC files?
No, they have to do it all on their own, apparently, because the filers are required to break it out immediately upon receipt of the contribution, and this form isn't due until December 31st of the year. So if I'm a filer and I get an LLC contribution, I have to endeavor to find out who is an owner now to break it out.
So we won't have a database for them to use then to identify the...
Well, at the end of the year.
But not when they file.
Right, correct.
Seems backward.
It was effective in 7 days, so we're scrambling on that one.
Okay. Any other questions? Okay, thank you. Then we'll move on to election operations. Tom Conley and Brendan LaValle.
Thank you, Commissioner. With regard to the primary election, a number of filings were received here at the State Board for both the 57th State Senate District and also judicial delegates and alternates. There's a prima facie report for ballot access, which is on the agenda for later on this meeting. We've also drafted a certification for the June primary. At present, there would be a Republican primary for the 57th Senate District and a number of primaries in the 8th Judicial District for delegates and alternates, or at least for those that file here at the State Board. We'll also be preparing for receiving the designation of early voting poll sites from the county, since that due date is May 1st, coming up this week. With regard to the voting machines for ES&S, SLI has completed their primary source code review and has submitted compliance builds to us to start testing. They also have started their secondary security analysis. We've also been working with NICE Tech for the secondary review of what SLI has done. So that process is with regard to Dominion, as was requested at the last meeting, the unit did undertake an additional review of the ImageCast Evolution, or the ICE machine, in conjunction with Dominion, SLI, and NICE Tech. The results of that review have been provided to commissioners, and I believe it's on the agenda under old business for further discussion. And lastly, for Clear Ballot, testing is expected to be completed in the next 2 or 3 weeks, and then the idea would be it would be brought before the commissioners at a June or July board meeting for approval for their modification. And then lastly, as Bob mentioned, with regard to electronic poll books, that's been consuming a lot of our unit's time with regard to developing the security, the network, and the functional requirements. We did finalize those. We did provide those to the vendors that we were aware of. We also provided information on our website, the applications for any vendor for an electronic poll book that wants to be evaluated for approval. The deadline is this Friday, May 3rd. There will then be a period of 2 weeks in which we're going to do some internal review of the documentation that's provided before we have in-person demos with the vendors towards the last 2 weeks of May. And the expectation is we would be done with the evaluation process for at least this initial round, anyone who submits an application by the deadline by no later than the first week of June. Otherwise, that's largely it, Brendan.
Any questions from the commissioners? No? Okay, thank you. And then we'll move on to NVRA, PIO John Conklin and Shelkhausen.
Thank you, Commissioner. The Public Information Office continues to be busy. Since the last meeting, the state budget was passed, which gave us a number of new responsibilities. Hot topics since the last meeting include early voting, time off to vote, continuing changes to the signature requirements for the petition gathering period, independent petitions and signature requirements, always campaign finance, some cybersecurity issues that always pops up periodically in the national press, and then the possibility of public financing for campaigns and the public nature of voter registration records. The unit participated in the monthly ECA call in April. We continue to be part of the meetings on the cybersecurity plans with regard to risk assessments, intrusion detection systems, and managed security systems. We processed 92 FOIL requests in March. With regard to the website, we posted, as most other units have mentioned their individual things, the Campaign Finance Handbook, an updated version of the Campaign Finance Handbook, the notice to filers regarding certain loans to candidates, a notice to e-poll book vendors, a notice to petition filers regarding the two-day overnight delivery requirement, and lastly, the updated version of the time off to vote notice for Section 3.110. For NVRA, we didn't schedule any site visits since the last board meeting due to the petition process at the local level, so we left the counties alone for the last month. With regard to website accessibility, we continue to have meetings on completing the contract with our website accessibility vendor, and we continue to plug away at making the documents on our website accessible. With regard to the PIO's position in the Secure Election Center, we filled it with the last vacant position at the beginning of April with a young man named Ryan Richmond, who has joined our staff. And lastly, we just launched the cyber hygiene training for 2019 to all the county boards and the state board staff. So, sorry, Bill. So, anything to add, Cheryl?
No, thank you.
Okay. Any questions of John or Cheryl? No? All right, thank you. And then we'll move on to ITU, Bill Cross.
Good afternoon, Commissioners. I'll start with projects, particularly Capus Vitus. Development continues with recent activity, continue to be focused on the EFS, or electronic filing system, particularly testing and report development. We've also, as was mentioned, reaching out to begin to gear up for training on the new system and working with trainers. We also continue work in implementation of the new secure app, the secure portal for accessing the system, including multi-factor authentication. Last month, we also provided a demo to the commissioners for the public-facing functionality of the system, and we are currently defining a similar demonstration for interested external parties. With regard to staffing, I'm extremely happy to report we've hired 2 people to fill vacancies on the project. One of these people started last Friday, and the other is scheduled to start on May 16th. That, at least in terms of state staffing, would be the first time that's been completely filled since I've been here, so very happy to report that. We are continuing on target for a soft launch in July with the Treasurer Beta Group. This is still dependent on some factors, including the data conversion effort, getting new staff up to speed, and of course the budget, but we're hopeful. In terms of NICE Voter, the State Board, along with our project vendor, completed our first disaster recovery testing exercise on the weekend of April 13th, which involved failing all NICE Voter operations over to our disaster recovery site and confirming our ability to run NICE Voter from that remote location should we ever have to, and failing back. We did confirm our ability to operate remotely. Testing also identified several issues that still need to be addressed to make this process more efficient, and we're working on those. We're also continuing development of the new Move application in-house. And as Bob mentioned and a couple others, IT has been integral, working with executive and other units on budget issues, including estimates for the new technology costs associated with new initiatives. And while availability of state funds for critical projects and operations continues to be examined, we're aggressively moving forward with the board's plan to secure our own elections infrastructure utilizing the 2018 federal cyber funds. We're also working on accessibility with PIO and other BOE units, meeting the requirements of the accessibility lawsuit, participated in the first administrative kickoff with level access, the vendor level access, and we'll be participating in the functional kickoff to be scheduled shortly. And are working on developing projects to meet criteria defined in the lawsuit for December 19, including PDF remediation on the website and updates to voter lookup, election night reporting, and of course the new Campus FIDUS system. Security continues to be our other major effort. Secure election staff has worked with county IT and boards on cyber incidents. Since our last meeting, 2 additional counties have encountered incidents, malware incidents that necessitated our bringing down the NICE Voter connection as a precautionary measure. Both incidents have now been resolved and are back online. The board's Chief Information Security Officer is currently attending the MS-ISAC, or Multi-State Information Sharing and Analysis Center, annual meeting in Denver this week with other state and local IT and election leaders across the country. In addition to multiple sessions on cybersecurity, he will be participating in a panel regarding election security and specifically New York State's efforts to assess and secure our elections infrastructure. Our countywide risk assessment has some attention, and we'll be sharing some details on lessons learned there. Our other county board cybersecurity efforts for the risk assessment, all 58 site visits have been completed, as well as the first county report for Schoharie. The remaining reports are expected to file shortly. Intrusion detection systems have been installed in 54 counties across the state, and we are now following up on the remaining counties to ensure that they either have existing IDS capabilities or intrusion detection capabilities, or facilitate installation of our offering or the federal DHS Albert offering. We're working with the managed security vendor to roll out the first three pilot installations of managed security services. And those are in progress. And as John mentioned, the board's created the new 2019 Cybersecurity Awareness Curriculum, training curriculum for state and county board staff, and notices should be rolling out as we speak, I believe, this week. The board is also now working on phase 1 of the Nice Voter Data Project with the SUNY Center for Technology and Government on a solution to detect abnormalities in data coming from the county boards and Nice Voter transactions and provide better analytics from that data. The first phase of that is us providing full transactional data to them from the system so they can establish what traditional baselines have been to compare to traffic going forward. We also continue to work on several security improvements in our own infrastructure. As I mentioned before when I spoke about the budget, including enhanced malware protections, multi-factor authentication for security, additional email security, as well as preparation for our own DHS risk assessment scheduled for late July. In terms of the website traffic analytics, unremarkable. It's about normal levels. It's approximately about 250,000 views a month for this time of year.
Any questions for Bill? No? Thank you. Next, we have Enforcement Risa Sugarman. I note that she's not here today, although I do believe she was invited.
Yes.
Correct? And I guess she's still refusing to come based on the litigation that's going on. Is that true?
That's correct.
Where's this litigation now?
The litigation is still pending and has been assigned to a judge, and both sides have requested oral argument, and the judge has as yet not scheduled it.
But all the papers are in.
So we're basically in the dark in terms of what's going on in that department. Outside of the statistics you gave us.
Yes.
Okay.
Right. Okay. Well, that completes the unit updates. So with that, we will move on to old business. And we have one piece of old business, which was regarding the security issue for the Dominion machine. I believe at the last meeting, the staff was instructed to meet with Dominion and Nice Tech and come up to a resolution of the issues that were raised regarding the security of the machine. And I guess I'd ask if there's a report back from the staff on how that was handled.
Sure thing, Commissioner. So as was requested by the Commissioners at the March 19th board meeting, the Election Operations Unit engaged NISTech, SLI Compliance, and Dominion Voting Systems to undertake an additional review of the ImageCast Evolution System, including but not limited to the security review performed by SLI as part of the original certification. The threat register documentation is provided in the Technical Data Package, or TDP, by Dominion. For the system and any other documentation deemed relevant to the quote-unquote design flaw as identified originally by Professor Andrew Appel and subsequently raised by Commissioner Kellner in his March 7th memo. As a result of these efforts, it was determined that SLI security testing of the Dominion source code provided reasonable assurance that malicious code, which could be triggered to enable the machine to print additional marks on an already marked ballot, is not present in the certified version. NISTech had originally determined that the level of risk for the proposed threat was considered quote-unquote low by the standards set forth by the National Institute of Standards and Technology, or NIST. It was then determined that additional compensating controls would lower the risk even further to the very low category, which is the lowest level of risk. As such, Dominion has submitted an updated threat register in their TDP, which now includes an entry for the, quote, tampering with installed software, which addresses the specific risk and provides mitigating controls. And should the Commissioners agree with the outcome of the review, the Election Operations Unit would update existing procedures to include a process for accessing the hardware counter for the printer as part of an audit process. And in addition, the poll site procedures would be modified to alert poll workers to be aware of the printer running when it should not be, as an additional check.
Okay. Is there any further discussion regarding that report, which the staff agreed upon as a solution to the issue that was raised at the board meeting?
I agree. Go ahead. Bill.
Go ahead. Commissioner Kellner?
Can you hear me?
Yes.
All right, well, thank you. I appreciate that the additional investigations were done by SLI and by NICETEC. And I, in general, accept the conclusions, particularly that of NICETEC and the threat analysis that the actual threat is low. And on that basis, I think that we can proceed with this, as the staff has indicated. But I have a couple of comments on it, because there are parts of it parts of the analysis that I think are misleading. The most important statement that I think is misleading is to say that they have analyzed the software to determine that there is no malicious software, software or source code contained in the approved source version. And I think that that's missing the point of what we were talking about, which is that it's with access to the machine, and insiders have access to the machine, that what was the possibility of installing malicious code, and how difficult would it be for that malicious code to trigger the subroutines in the source code that would enable the printer function. And I believe that NICETEC, in fact, did analyze that and came to a conclusion that the actual report summary doesn't explain that adequately. And I think that a lot of people who read it then, who are experienced with computer science issues, come to the conclusion that the examinations were not as robust as I believe they were. So I wanted to make that comment. And several people have written the commissioners. We always appreciate those comments. Joseph Caneri, who is a PhD computer scientist who is on contract with DARPA and the Office of Naval Research on security issues, makes a very cogent suggestion, which is that if Dominion is really concerned about allaying the fears of the public, then they should make one of their machines available for use at the DEF CON election workshop that's coming up soon. So thank you for allowing me a minute to have those comments, and I do appreciate the efforts that everyone has gone into to further investigate the vulnerabilities, and I believe that the reports do provide some assurance that it would be extremely difficult to accomplish what Professors Appel and DeMillo have pointed out.
Okay, thank you, Commissioner. Are there any other comments by the commissioners? Okay, I don't have any. I think we accept the report by the staff, and we appreciate all your work, and hopefully we can move on and continue with that process.
Okay.
Okay. That completes old business. I don't believe there's any other old business to come before the board, so we'll move on to new business. And the first of the new business are ballot access rulings. We have been provided by the staff with a report of all petition challenges or findings by the staff regarding the sufficiency of petitions filed at this office for this year's primary election. And I have a report before us. I believe, Commissioner Kellner, you have a copy of the report as well?
Yes, I do have the report.
Okay.
And I move the adoption of the staff report.
So I have a motion to adopt the staff report. Is there a second?
Second.
And all in favor?
Aye.
Aye. Opposed? So the staff report is adopted as provided to the commissioners. Next on our new business agenda is the early voting regulations, which were provided to the commissioners by the staff. These are regulations regarding the implementation of early voting by the counties in New York, and I believe these are emergency regulations that we're putting out today because of the timing. And these will go out then as our regulations, but then they'll go through the normal process of being put out in the state register, comment, and come back to us. And when will that come back to us?
From the date of publication in the register, they have to age for 60 days
Okay.
for public comments, and then anytime after that, they would come back. So, Commissioner, our intention would be that as soon as that happens, at the first meeting after the aging process, they would
So
be
we
back
would,
on the
we would
agenda.
expect later this summer, they'd come back for final approval.
Yes,
But in the meantime, this will provide the counties with direction on how to implement the early voting for this fall. We have, let's see, a couple different versions, is that right? Or
Three separate.
three separate ones? Should we take these separately or take them individually, or what is the commissioner's prerogative? We
We've all
have,
read them, I think.
Yeah, we can do it all.
we have three separate,
Just read out what they were.
yeah, there's the amendment to Part 621019 regarding minimum required voting machines and privacy booths at early voting sites. There's 6210.18 relating to audits of voting machines at early voting sites. And then there is the, I'm sorry, is there a third one or is it
6211.
211, the first one on the.
I'm sorry, 6211 regarding early voting. And those three are before us. Do you want to take them as a package or individually? All right, is there,
I have a question
Sure.
that in several places in the regulations, there is a requirement that procedures or other documents be submitted for approval of the co-executive directors. And in several places, there are deadlines for the co-executive directors to approve or reject. And I wonder if there's been any discussion of what the default provision is if the co-executive directors do not agree.
I would direct that to the co-executive directors. Have you considered that possibility, that you two cannot agree on a county's proposal?
Could that possibly
And then what happens?
How could that possibly?
Commissioner Spano doesn't see that possibly happening, but if it does, what would be the,
I think we would follow the same path if the four commissioners disagreed. And our concern was, did we have to have a meeting at the commissioner level or the staff level to move this documentation through? So certainly, it would need to get escalated to the commissioners. I don't know what our dispute resolution effort would be, if it's a 2-2 or a 1-1 divide, other than to try and resolve it. In some instances, we speak to, there's a plan in place. You know,
well, I would think, if I could just speak to this for a second, I would
Hasn't
think,
been discussed.
I would think absent any other proposal, that a failure to agree would mean the proposal is not adopted. So if a county submitted something and the co-executive directors couldn't agree on it, it would not be accepted, and that county would not have an accepted document to work off. So then you'd have to try to resolve
Kick it up
it.
to the commissioners.
They could kick it up to the commissioners, and we could try to resolve it if
Right.
that makes sense. But I don't know, I mean, timeliness, I know, is an issue here, which is why the co-executive directors are given this authority, because we need timely action on these issues, so we don't want to delay them either.
Well, I know, I would agree with that. I mean, it would extend, we can't change the statute because the statute, all we're doing is delegating the authority that the board would have in order to make a decision that would require a majority vote for the action to occur. So all this did was, in order for the essence of time, was you have now, in this instance alone, you delegated that authority down to the co-executive. So it would be the same process. We wouldn't be able to go forward, so the answer would be, it's not accepted unless. I mean, it's only instances where the statute has reversed that, where we have the default where it's good. Otherwise, there has to be an agreement for it to go forward and be accepted. So that we have not discussed specifically how we would, the mechanics for that, but I don't see under the law how we could do anything other than that. And certainly we can have an appeal process up to the board, which we're not anticipating, but that's going to be a time issue because these are very short time frames that we're dealing with, which is why you delegate it in the regulations.
So Commissioner, I think the default would be, it would be kicked up to the board for us to resolve if the co-executive directors can't resolve it.
All right, well, I agree with that. I would request that the staff consider clarifying that when we adopt the final regulations, but I support the emergency regulations as they're drafted now.
Okay, fair enough. Then I'm going to propose that we take them as a package, all three of these early voting draft regulations for emergency adoption. Is there a motion to adopt? And a second?
Second.
All in favor? Aye. Opposed?
Aye.
I'm sorry. Was that
an aye.
in favor?
I voted aye.
You were aye. Okay, so all, there was a unanimous aye vote on all three of those proposed regulations. So that concludes those regulations. Next, we move on to the county grant program. I'm sorry. What did I miss?
Contribution
Contribution limits.
regulation.
I don't have that.
C?
I don't have that. Sorry.
Contribution limits.
Oh, I have the wrong, I'm sorry. Thank you. Contribution limit regulations. Maybe you should explain that to us before we adopt it.
Sure, Commissioner. This is this particular resolution is completing the adoption of the publication of campaign contribution limits that is required every 4 years when the contribution limits are by statute automatically increased according to the CPI. The board already adopted them on an emergency basis. To permit the publication timely as required by law, and now at this point the board is simply adopting the ongoing publication of those limits permanently until the next adjustment.
So is it fair to say this is really a ministerial act that we conduct? It's
Yes.
not at our discretion, we just adopt them pursuant to statute?
Yes.
Okay. So this is the final adoption of these? I'm sorry, Commissioner Kellner, you have a question?
Yes, I agree it's a ministerial act, but am I correct that the part of the regulation that sets the limits for New York City is actually different from the limits that are in effect because of the court decision saying that the New York City law takes priority over the state law? And I'm wondering whether there should be a footnote or some advice to that effect in the regulation, just as we put it on the election calendar when the state law has been overridden by the local law.
So in New York City has, pursuant to its home rule authority under the charter, has adopted for races in New York City lower limits. So there are a couple limits in the 6214 that actually, due to the superseding limits that the New York City has adopted, are in fact, from the perspective of the regulated public, lower. And so the recommendation is that we provide some sort of annotation to that effect that would indicate to the regulated community that they should look to that body of law. We provide that same annotation on the political calendar now. And I think the question would be, how would we best effectuate that? One easy way for us to effectuate that would be to simply place an annotation on our website next to these, which would not require an actual change to the text of the regulation. Or we would, and in our book that we publish, we would be able to put an asterisk. The third option would be or an additional option would be that we actually amend the regulation. Are you suggesting an amendment to the regulation, or just framing the regulation in terms of how the public sees it?
I'm suggesting an amendment to the regulation to add the asterisk, and the asterisk would simply cite the local law. And the reason for that is that there's multiple source material that people look at, not just going to our website, but if they go to the various codifications of the regulations that are online, either through Lexis or Westlaw, or through the government website, they wouldn't see it. And an annotation that would appear on our website wouldn't necessarily show up unless the annotation were part of the regulation. So if we're taking the trouble to amend the regulation to bring it up to date with the new numbers, I would recommend that we start adding that asterisk.
That makes sense to me. Is that acceptable to everybody?
Do the emergency regulations sunset? And
They sunset within 90 days of when they were first published.
so should we consider adopting this set so something is in place, and then start the amendment process so that I'm just.
Well, I guess the question is whether this
be a
is
gap if we follow an amendment.
right. And I guess the question is whether this would be considered a substantial amendment. Because if it's not, then we could just add that amendment now and publish it in its final form. Personally, it doesn't strike me as a substantial amendment.
I would argue it's not substantial
Right.
since it's in the law.
I would agree. I think that's a fair reading of this, unless someone here
No,
agrees.
so the motion would be to adopt this finally, and then we'll
With
make,
the asterisk amended.
with the asterisk referring to the city law.
Correct.
Yes.
And
Right.
make this final adoption.
Right.
Is that acceptable to all concerned?
Yes.
All right, so the motion is to adopt these finally with the asterisk included. And there's been a motion and a second, all in favor? Aye.
Aye.
Opposed? He's up. All right, that's unanimously adopted as well. So those are finally adopted with the noted amendment. That completes that. Then next is the county grants program. And this, we have the grant program that was adopted in the state budget for our counties regarding early voting, and also electronic poll books.
Correct. Chapter 53 of the state budget and part of the aid and localities budget provided a $10 million fund, which is to be made available to local boards of elections for reimbursement of costs related to the implementation of early voting and eligible expenses, which is pursuant to a plan which must also have the approval of the Division of Budget.
Now, do we have to adopt something formally here to disperse this money? I mean, the $14 million, as I understand it, was statutorily determined how that would be distributed based on a formula? Or is that not true?
Well, you're referring to the second chapter, which is chapter 54, part of the capital projects, allowed for $14.7 million, which was made available to the local boards for initial technology costs for electronic poll books, any amounts that the state board may need for the implementation of electronic poll books, and then the remaining funds are made available to the county for for any eligible costs for electronic poll books, associated software, on-demand ballot printers, and obviously the cybersecurity software that goes around those items. And those are, the remaining funds are apportioned based upon the number of registered voters in the county. So and there is no division of budget approval for that. It is essentially a formula, with the one caveat that it is made for the initial technology costs and then the remaining funds for the additional items that are available for the counties.
So let me understand what you're proposing. So let's focus on that fund first. So you're proposing that the distribution of this money be based on number of poll sites? So you would...
Early voting poll sites.
We would authorize a $15,000 allotment per early voting site for electronic poll books for that county?
For the initial cost, they allow early e-poll books, ballot on demand printers, the software to operate the system, and any security connectivity are authorized expenses under that capital fund. So our first would be based on the number of sites actually selected by the counties, which is due on May 1st. That's why we're not so the plan is what we're asking consideration of, not necessarily the chart that gives you the dollars.
Okay.
That's our estimate based on some of the information we anticipate receiving. But once we get the counties to actually tell us the number of sites they've selected, we'll firm that up. So we're recommending a 15,000 base amount for each site selected, and then the residual dollars to be apportioned based on the February 1 registration table. How do they, proportionality. And with regard to the capital money, we do not yet have a firm number of what we think it will take to roll out at the state level, the examination of this equipment. But we're asking for initial just to set aside $700,000, assuming that it will be less than that, and then we could, once that final accounting is done, include those dollars also for the county. So we would envision amending it once we know that number, so that those additional dollars would be sent to the counties based on the same per capita apportioning.
So is it your anticipation that all the counties are going to be buying e-poll books? I mean, I noticed a number of our counties, in fact, a large number are anticipating one early voting site. And I'm expecting that in those cases, those counties don't really need electronic poll books to implement their early voting, because they'll have the poll books there, all the poll books, so they can just use their poll books instead of having an electronic version around the county. So there's a chance I would think a good chance, many of those counties won't really need electronic poll books or want them.
Not everyone will need them initially.
So if we're going to allocate the money, if these counties, and as I say, it's like 29, I think, that are only going with one site, are we still going to give them money for an electronic poll book, even though they say, well, we're not going to buy them because we don't need them, or how's it going to work?
When the state board asked the survey question that was requested of us, the Senate and Assembly fiscal committees, there were only about 4 or 5 counties that said they were planning on not using e-poll books this year. There may be other expenses that they have that would qualify, but these are capital funds. The other counties, even though they thought that they would only have one site, still indicated a desire to have e-poll books. Our estimate, and it's only an estimate because we don't have contracts in place yet, is approximately $2,500 for each e-poll book system at a poll site. We recommend a minimum of 2 because every poll site you go to has the book divided alphabetically in half anyway, that there's already an existing 2 services available at poll sites, so a minimum of 2, and an estimate on ballot on demand, if it be needed, of about, I think operational staff gave us an initial estimate not having final contracts in place of about $8,000 for that printer. So that's how we came up.
And just to note that
Some of the
that bill
residuals.
hasn't been passed by the legislature yet, that relates directly to that, so that might be, account for some of the delay that some of the counties are having with regard to the numbers of those types of things that they need.
Well, the law allowing the e-poll books themselves wasn't
No,
signed
ballot on
until
demand, yeah.
April 12th, so we've been anticipating it passing. It finally did on April 12th, so now we can put some of this in place. So that was our estimate by the time they have, you know, 2 systems plus a ballot on demand if they need one, and some of the other support costs was an initial cost of $15,000 per site. That may vary, of course, for the larger sites than the smaller sites. It also takes into consideration those rural sites that may have no other source of money, but because geography, they need more than one site, even though they're not fitting into all of the other wording to require.
No, I mean, my concern is that, you know, a lot of these upstate counties have identified one site, and as you know, many of these are large geographic areas. So while the statute required a minimum of 1 per 50,000 voters, in upstate, that's not really the issue. The issue isn't number of voters, it's distance. It's an issue of if I'm in many of these upstate counties, it's not I have a lot of voters, it's just voters have to travel long distances if there's only going to be one site in that county. So, you know, distributing the money and letting counties know you're going to get some help with your early voting site, I think is important to them as a message, so they know that they don't have fewer sites because they don't feel they can afford it. That I think it's important for us to tell them up front, we will help you fund your site to try to encourage them to open more sites if they can, because these are large counties, large distances, not dense populations. So the bill isn't going to drive them as far as how many sites they need. It's, I think, geography that should drive them, that you need to provide reasonable access to their voters within a large geographic area. So I think it's important to get it out that if they open sites, we will help them. Because I know a lot of these counties have told us only one site, but that may have been determined because they thought it would be too expensive for them to open up multiple sites. I would like us to have the ability to say to them, well, if you do open up additional sites, we will help fund them. And I know we've got really 2 pots of money here that we can use, this pot and the other $10 million pot for early voting sites. And I think I see that you've designated $15,000 out of each pot for each early voting site. So that'd be $30,000 that a county could get in order to open up a site, which I don't know if that's adequate to open and populate a site. I'm not sure that's quite enough money. I don't know exactly what the counties have told you. It may depend on the county whether that's enough to, you know, purchase all the equipment they need, rent the building, and provide personnel at the site for that lengthy 10-day period. But I would like to see it, you know, done in a way that the counties have an opportunity to know, if you open, here's what you're going to get, and then you make the decision locally, but we'll help you fund it.
With regard to the 8 to localities portion, the statute requires a plan approved by the division of the budget. One of the questions that the co-executive directors asked the executive chamber and the division of the budget was, how do they see that process working, since it's money that goes through the state board, but it didn't require us to develop a plan. And the answer that we received was they had asked us to recommend a plan, so that's why the plan that we have put together is one that we are asking to recommend to them as something that accomplishes exactly what I think you've articulated. What would be necessary?
Well, here's my concern, Bob. Let me tell you my concern. My concern is that they are due to provide us with the number of sites by Wednesday. Statutorily, they've got a deadline that's looming very, very quickly, where by Wednesday we have to, I think we've only gotten a couple so far, but by when. So I just want to know that they have adequate information from us about our ability to help them before they decide. Mm-hmm. So we're not, you know, telling them afterwards, oh, you're going to get this money, and they already locked themselves into one site and are saying, well, gee, if you'd have told me you're going to give me $30,000, I would have opened a second site, which I think in, you know, a lot of these upstate counties could be helpful. So I'm just trying to figure out how we would make that work for them. I don't want to lock us into a way that, sorry, we've already allocated the money, it's gone, you can't open it, we can't help you with another site now.
It's important that it's a reimbursement program too, I think, for them to know. They have to have the money to give out.
Fair enough.
And then get it back.
No, fair enough. I understand. Maybe they can't do that. I understand this is really an unfunded mandate we've laid on these counties now after their budgets have already been in place because they have a January budget period. So I know they're kind of caught short, but I'd still like to be as helpful as we can. And I'm just concerned about all these upstate counties with these large geographic areas servicing with one site, and are we making sure that we're telling them we'll be helpful if we can to help you open sites if you want to. So I don't know how we get that out there. I'm just
Well, if this plan is of a consensus that you approve, then we can certainly get it out today. It was generally discussed with the counties in the call with all the county boards of elections on Thursday of last week. We generally described a method where we would recommend allocating based on the number of sites with the residual. We talked in general terms of the number of 15, but I don't, we try not to presuppose what you'll do. So we didn't want to get so far out in case you had put it a different way.
I think we should approve this, and you should go out and make that notification.
That's fine.
It's an appropriate, idea.
Okay. Okay, do we have to approve something? Is this a motion and a second, or are we okay with our?
I don't think we need a formal vote, but certainly if the four of you agree with this approach, it's
Okay.
helpful to know.
Okay.
Yeah.
Any other discussion on that issue? No? Okay, then we will move on to the last item, which is management confidential salary adjustments. I believe the co-executive directors have to be approved by this board
That's correct.
for raises,
And you have approved everyone else on the staff, right?
That's correct.
and the rest of the staff is taken care of. Is there a motion to adopt a 2% raise for the co-executive directors?
I'll move.
So moved.
Second.
Second.
All in favor?
Aye.
Okay. And opposed, that is adopted. And that is the end of the meeting, unless there's something else that needs to be brought before the board today.
Just on next board meeting.
Next board meeting will have to be determined. Now, I believe there's some need to meet in early June.
That's
Is
correct.
that correct?
In order to make sure that we have the approvals for the electronic poll book list in place.
And do you have dates that you feel are necessary for us to meet?
It should be no later than the second week of June.
No later than the second week.
Preferably the first week, but 3rd through the 7th is the first week. 10th through the 14th is the second week.
How does the 6th look for people?
I'm good.
I'm good.
Commissioner Kellner? June 6th?
I don't have a full calendar in front of me, but we could tentatively say that, and if I have a problem, I'll let you know.
Okay, then we'll tentatively set it for Thursday, June 6th, pending the approval by Commissioner Kellner. All right, with that said, is there no other business to come before the board? I'd entertain a motion to adjourn.
So moved.
All in favor?
Aye.
Thank you, and we'll see you on June 6th.